corporation or by means of a general law, okay, or general incorporation law under which person deciding to be and act as a corporation may incorporate. In the Philippines, the general law which governs the corporation or the creation of private corporation is Batas Pambansang bilang 68. Now we have RA 11323, 323, 232, okay? That was signed into law on February 21, 2019. I repeat, the law that authorizing the formation, organization of a corporation is Batas Pambansa bilang 68 that took effect on May 1, 1980. It was revised by RA 11232, okay, which is a general law. I repeat, the law authorizing the creation of a private corporation is a general law, while the law that creating the city of Manila, city of Pasig, Mandaluyong, okay, or Cebu City, or Angeles City, or Dagupan City is by special law, okay? And who is duly authorized to create this law? It is the Congress. If you will be asked in the bar exam, what entity or part of our government that is authorized to form, regulate, okay, has the power to regulate the formation, organization of a private corporation? Your answer is the Congress, okay, through general law, which they did, okay? It is the Congress that has the authority to regulate the formation and organization of a private corporation. Whether that corporation is a stock or non-stock corporation, okay, whether that is a special, created by special charter, or is that of a government-owned or controlled corporation class. Now, the possible question in this creation by operation of law is that, is mere agreement or consent of the party to form a corporation sufficient? No, because corporation is created by operation of law. There must be compliance with the legal requirements provided by law, such as Article of Incorporation, the stock, what we call the stock holding requirements, the share requirements provided for by law or the limitation on foreign-owned and controlled corporation, the capital requirements, the paid-up capital, in short, the legal requirements provided under the Corporation Code. If you do not comply with these requirements, then you will not be allowed to form a corporation. You will not be allowed to form a corporation. So that is clear in your mind. I ask you how corporations are created or formed. Well, your answer is that the corporation, okay, is formed only by operation of law or created only by operation of law, either by special law or a general law. What does it mean? Special law refers to those corporations that are created under a special charter, like your City of Manila and City of Cebu. General law, we are referring to the corporation, either stock or non-stock corporation, that are created under the revised Corporation Code. Okay, that are created under the revised Corporation Code. Now, Suppose there is a bar question. Can Congress create a special law creating a private corporation? No, because there is a constitutional injunction or limitation to the Congress that a corporation can only be created by a general law. Okay? Now, if the corporation they will create is a corporation that is for a special charter like city or the LGU or the government-owned and controlled corporation, then that is allowed. But as a private stock or non-stock corporation, they are not allowed. Now, it takes that one question in the bar regarding the creation of a corporation. In 2000 bar, there is a question. The question goes like this. Since February 8, 1935, the legislature has not passed even a single law creating a private corporation. What provision of the Constitution preclude the passage of such law? You look at the provision on Article 12, Section 16. Okay, what is this? The Congress shall not, except by general law, provide for the formation, organization of a private corporation. Government-owned and controlled corporation may be created or established by special charter in the interest of the common good and subject to the test of economic viability. Okay, so that is a very beautiful provision of the 1987 Constitution. So it's very clear that the formation organization of a private corporation, either a stock or non-stock corporation, is by a general law. Okay? And it through the Congress. While government-owned and controlled corporations are created only by special charter, okay, the same must be in the interest of the common good and subject to the test economic viability. That's the 2008 bar exam. Before I forget, class, a corporation, okay, a corporation as an artificial being, in that artificial being, okay, is not entitled to moral damages. Okay, corporations are not entitled to moral damages. The existing rule is that moral damages are not awarded to a corporation it is incapable of feeling or mental anguish. A corporation is incapable of fright, anxiety, shock, humiliation, and physical or mental suffering. Mental suffering can be experienced only by one having a nervous system, and it flows from real, ill, sorrow, and grief of life. A corporation not having a nervous system or a human being does not experience physical suffering, mental anguish, embarrassment, or wound feeling. Exception on award of damages, if any, only apply pro hac vice. The grant is not automatic. The claimant must still prove the factual basis of the damage and the causal relation to that of defendant acts. But there is one exception. In case the good name of the corporation is besmirched, then they are entitled to damages. In fact, there is a recent case decided by the Supreme Court in the case of ABS-CBN Corporation versus JMA 7 Network. That is the case decided by the Supreme Court on moral damages. I stop from there.